Inside Utterance here. My name's Hella. I'm sorry for the wait. Today, good, this morning, it's been nuts and it's so cold here. And you probably, if you have a look at our temperatures here in Brisbane, you're probably going to look at it, convert it to whatever your measurements are, and go, that's not very cold. But for me, I'm kind of small and I feel the cold pretty bad. So, anyway, yeah, I've been freezing and I've been trying to prepare for the stream and get my little girl off to school and all that kind of stuff, and also watching Dali's show whilst doing all the things and going, oh, I'm freezing, and whining and whining and whining. But here I am. Thank you for waiting, everybody. I'm sorry. Hello, everyone. Hello, hello. Half Irish. You read my mind. I'm like, hang on, it's still July. It's still July in North America. The other side of the world, it's still July in the past. So I'm going to keep my July membership challenge going. I need 15 more memberships to make it to my last goal and have to do 3 more challenges. So I'm 2 behind because I had the flu, which is going out and asking Australians what they think about Donald Trump and American gun laws. And I haven't even thought of what my third one would be if I get to 15 more gifted memberships today. So let's see if we can do that, guys. That'd be awesome. Hello, Q. Like and subscribe to Excited Utterance. You're very nice, aren't you, Q? Q came over from Cat Not Williams. So thank you for that. And everyone like and subscribe to Cat Not Williams as well. She's lovely. And that's very sweet of you to come over and be very supportive. And I also met you over on Court TV because we were watching the verdicts yesterday in the ballerina trial. Good to see you here. Hey, Christine Fortunato. Lovely to see you. Hey, Donna Buckley. Sarah will be granted a continuance. All she needs to do is ask. Well, she has asked. It's just she needs to ask like a lawyer, I guess. She needs to actually put in a motion for continuance. Now, today, what we're going to be doing is we're going to be looking at the motion she has put in, and they're not too bad, really, considering she's only got a pen and paper, and she is writing motions. She's lawyering like a lawyer. So I'm kind of confused as to why she hasn't actually just asked for a continuance, like a motion for continuance, but she's done something, so we'll go through that. Hey, Chitty, sup? Sup, Chitty, good to have you here. Hurry, Hella. Look, I'm trying. Trying. Sarah can't wait forever. Justice for Sarah. Justice. All right. Yes, last call, 1st of July. Sorry, 31st of July. And you read my mind. Hello, Flash fan. Good to see you. And Josie's here. Nice to see you, Josie. Alrighty, where is my co-host? Oh,
hey.
There he is. Good to see you. Thank you also for your wonderful skills in getting documents. I didn't realize it was so easy to get the Sarah Boone documents. That's why everyone's always got them all the time. And you gave me the link and now I can get to them myself. So thank you for that. But it's not so easy to get all the documents that you always get because you've always got all of the documents. All of the documents. Always.
Yes.
Yes, you do. Hello.
Hi.
Ali. Hi. You're busy chatting to people, are you?
Yes.
Look, great minds.
Right. I found the response to Sarah's motions.
Oh, the one that was confidential?
No. The other one, as Flash Fan said, the judicial, what are they called? Judicial Administrative Commission, basically responsible for what costs they give a potential or a defendant, like public defender fees, expert fees, investigator fees.
They came back to her with the costs.
Or what they will or will not cover.
Really? Okay, sweet. Well, we can have a look at that today. Hello, Max. How are you?
It's 5 pages.
Hello. How are you, Max? Max is quite disappointed in excited utterance. Male single audience. That is, not one has stepped forward to claim their prize by declaring the magic words, I can fix her. The misogyny. Shame. Shame. Who? I don't need fixing. I'm fine. Look at me. I'm perfect the way I am. No need fixing. Or do you mean Sarah Boone? Do you mean Sarah Boone?
Oh,
Oh, Sarah Boone can fix. I
I'll
don't know if
pass.
anyone can fix Sarah Boone. Why would anyone want to fix Sarah Boone?
She's high maintenance.
Well, she's that. Plus, you'll end up in a suitcase, and no one wants to be in a suitcase going, Sarah, Sarah. Oh dear. We always love you being here, Max. All right, we've got a fair bit to get through, so let's do this, shall we? They objected to certain things, did they? Ooh.
Yeah.
I'm not surprised. They're not going to give her everything they want, everything she wants. No way. Does anyone want to fix her? No. That's a shit ton of work. Okay, now as you know, I have a little bit of a different opinion about the whole Sarah Boone situation to most other people. And that is that I feel a bit sorry for Miss Sarah, especially recently, because I feel like the judge is trying to just teach her a damn lesson with this whole, too bad, so sad, you're all on your own now, and the trial is still going to be in 2 months' time. And you have just been a big pain in the butt to everybody, and you've used up all your chances, and now you're pro se, even though you don't want to be. Right? And she's sitting there going, well, now what do I do? And also, can I please have my discovery? I don't have access to any discovery. And then there's this prison break guy who's supposed to be digitizing the discovery after the discovery deadline, by the way. Right? So the discovery deadline was 22nd of July. And he comes in and goes, oh, yeah, I'm going to digitize the discovery, but my son's wedding is end of July, early August or something. And so therefore I can't come in that week. And so can I have till, I don't know, 5th of August? And Sarah's just sitting there like, and Judge is like, oh, well, congratulations. Sure, you can have till the 5th of August. So Sarah doesn't get to have access to her discovery because she can only have it digitally. She doesn't get to have access to it until the 5th of August. That means that she effectively gets less than 2 months with access to her discovery digitally only during the days between 9 a.m. and 4 p.m. on a laptop, which may or may not keep charged during that time because, as we talked about the other day, she's not got access to a cord either because of choking hazard. Between now and then, and then the trial is October. That doesn't really sound fair to me. I don't feel like that's okay. I don't really like what's happening to Sarah Boone right now. I feel like the judge is just trying to teach her a lesson for being a smarty pants.
Yeah.
And that's not how the justice system works. If she's going to pay a penalty for all the things she's done, that's what happens at sentencing. That's not what happens now. So I know, like, we all find her really amusing, but I just don't really like the way this is going down. So that's how I feel about it. Oh, sorry, what did you say? I apologize for last stream. I had strong thoughts last time. Don't apologize. It's fine, Flash fan. We love having you around. And you know what? I super enjoy it when we all can have respectful, interesting discussion and we're not all just like saying the same thing all at the same time. Hello, Rosalind. I don't understand why they can't give her access to the paperwork in a room in the jail until everything is scanned in. Yeah. What's the big deal? What's she going to do? Give herself paper cuts?
Never know.
Create some sort of raft out of it?
USB drive is a choking hazard.
That's a really good point, Rosalind. Why can't they put her in a room with the paper? and then take the paper away at the end of the day. That's
Well,
excellent point.
the theory,
Excellent
I
point.
guess, is they are not lawyers. They are not able to have the custody of her discovery.
Oh, that's right. That's
It's
what
a
they said.
security issue.
That
I mean,
that no, they said they haven't got space.
well, and space, but
They
yeah.
have that. They don't start a fire, like rub the papers together. Yeah, no, they said that they don't have space to hold the boxes.
Yeah.
Right now, I don't believe for a second they don't have space for two boxes, but I think probably what they mean is that if every inmate who wanted access to the discovery were to there say, if she gets her boxes, then I should have my boxes,
Yeah.
then therefore they would need to house all of these boxes of discovery for all these inmates. So, okay, I get that one rule for one person can't be one rule for everybody. That makes sense. Max, right to discovery, albeit her consenting to delays, right to counsel, regardless of the back and forth. Could she ultimately get out of her situation through these seeming violations of her right? That's exactly what I've been trying to say. And you know what? I had a look at the judge's order, or his justification for why she has now forfeited her
Hmm.
right to counsel. I had a read of it because he keeps referring to it as this 16-page document. There's only like one page of it that talks about her forfeiting her right to counsel. And he has referred to some case law. Um, I don't know how he expects a layperson who's in jail to go and check the case law and
Hmm.
see whether or not those actually stand up in relation to her, what she's done. But there is some footnotes there, and the footnotes refer to the couple of cases that he's brought up, and they talk about uh, defendants who have abused and threatened their public defenders, and so those public defenders have had no choice but to recuse themselves. Kind of, if you remember Shabusiness style, remember when Shabusiness sort of
Oh, yeah.
like lashed out
Yeah.
and
Attacked
like
her lawyer.
physically threatened? Yeah, so those lawyers had every right to feel like scared and worried and didn't
Yeah.
want to be in that situation. Now, it's not apples for apples, I don't feel. Like, she's just been super duper annoying. Also, there haven't been 8 or 9 attorneys. There's been 4, right? When it comes down to it, there's been 4. The others have conflicted out. So everyone
Yeah.
keeps saying, oh, it's been 8 attorneys. No, it's been 4.
So they just assigned one to her and they're like, okay, well, I can't because of a conflict. And they gave her another one.
Yeah. Rosalind, the other inmates aren't representing themselves, no, but there there are reasons why there would be inmates who would want to have their discovery with them. So, for example, I mean, I know when Zach was in jail, he had discovery with him, didn't he,
A little
Darlie?
bit.
Yeah, and it was a problem because people would try and steal it
Yeah.
or get hold of it, and then
Snitch.
like that, you'd have problems with snitches. So,
Same thing with
I mean,
Mark Jensen.
Mark Jensen.
I mean,
Yeah,
guilty
yeah.
or
So
not, but yeah.
exactly, exactly. Law books are in most prison libraries. If she's not in solitary confinement, she'll have access to it. And clearly, she does have access to some law books because in a minute, we're going to have a look at what she's written, and she's not silly. I don't know if she's really a straight A student or not, but she has done some research. During the Darrell Brooks trial, I believe the reason for the judge's extreme patience was so that the probability of a mistrial or even claim for mistrial could be shut down immediately. Yeah, I couldn't stand her.
Yeah.
I found her to be the most infuriating judge I've ever watched. But
But
yes, she
she
was
made
trying to
that
avoid a mistrial.
and she made
Yeah,
that conviction iron proof.
yes, exactly.
Whereas this case is ripe for appeal
I feel that it
if it
is.
goes forward.
I feel that it is. And that's the thing. I'm really surprised at all of the lawyers that I've been watching, and I'm not going to name any. It's just I've been watching a few that I don't usually watch. who are following this carefully, and they just seem to be saying, no, she's been warned, she's been warned, she's been warned. And to me, it just seems like, has she really? Like, is there really enough there for her to not be able to appeal this? If she were to get an appellate lawyer, and a good appellate lawyer should be able to pull this apart, you would think.
Steve Gosney.
Yeah. 100%. Yeah, what's Florida?
He'd actually probably enjoy that.
Yeah.
The law, the legal aspects of
absolutely.
this. Yeah, he'd love
Yeah.
that.
I mean, I'm nobody.
Yeah.
But someone like Steve, a really good Florida appellate attorney, should be able to
Constitutional law.
pull this thing apart. You
Yeah.
would think. Hello, Ronnie. Good to see you. Good to see you. She covered her ass even though it drove us nuts. Yeah. Oh, what's her name? Doro.
Yeah.
Doro?
Yeah,
Oh,
Doro.
God. It just reminded me of Sorrow.
And she ran for the Supreme Court of Wisconsin and lost.
Oh, jeez Christ. I couldn't handle it. She did some other trial at some point in time, and I just was like, no, I can't.
The eye drops one.
Oh, the eye drops one. Oh.
Yeah.
And then there's so many wine mums in chat going, I love her, I love her. And I'm like, I can't stand her. Anyway, sorry. She needs Jose Baez. Everyone in Florida needs Jose Baez. Who doesn't need Jose Baez? The man has balls the size of my house. He has the biggest balls ever. Anyway, sorry, we're just completely getting off track now. Okay. So, let's see how good she is at this. So, she has started to write motions. Good on ya, Miss Boone. So, she's gone, well, you know what? If you're going to treat me like this, if I'm my own lawyer now, then I suppose I better start acting like a lawyer. She hasn't got any pretty fonts or anything like that. She doesn't know much about typesetting, but she stayed within the margins, and she's pretty good at her penmanship because she's been working on that for a few years now. So let's just see what she's got to say. Darlie, would you like to read?
Yes.
Here we go. Here we go.
Temporary motion for reservation of proposed costs to acquire investigator for defendant's trial. Defense in trial. Comes now, Sarah Boone.
Comes. Oh, she's even got the wording right. Comes now.
I'm gonna come. Pro se indigent.
Please no.
Defendant respectfully request from this court the reservation of proposed costs to acquire the investigator for defendant's defense in trial. Investigator TBD. Total amount requesting TBD.
TBD.
How to calculate unknown by defendant TBD. Reason: no discovery or case materials provided to defendant from the judge.
Okay, notice that's all in capital letters. And that's look, no, fair enough. And she put a little asterisk next to it as well. So that's her way of being really clear. I don't know, because no discovery or case materials have been provided to defendant from the judge.
No discovery had been sent.
Okay, keep going.
This temporary motion is being submitted to meet the delegated due date of 7/22/24 by the judge in court as stated to the defendant in the order dated 6/28/24. The defendant is trying to avoid any further persecution and penalization from the judge in court while vigorously attempting to proceed in her forced position of pro se attorney and representation of self. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court had forced the middle of this
Submittal.
temporary motion. Once the defendant has finally received, she will be able to proceed, will revise and resubmit this motion upon completion of her review and research of the contents.
Okay.
Oh, should I
That's
do
a
this as a
really.
female?
No, you're right. I think this is good. I think this angry man is quite good. She's very wordy. What she's saying, the exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court
Basically,
had forced the submittal of this temporary motion.
she's saying once she gets her discovery, she will be in a better position to know what she needs for investigators and will update.
Okay.
But I guess the judge was like, you need to submit this now.
Okay. All right. Keep going.
Wherefore, Sarah Boone, pro se Esquire, indigent defendant, respectfully requests to the honorable.
Sorry, Donna. That's a really good point, but
I've got like two voices, honestly.
he's got three voices.
Three.
So you've got Angry Man, you've got Valley Girl, and you've got Becky Hill.
Yeah.
Right. So
and Swedish/Indian.
Yeah, Swedish/Indian, which is like Nick Starro.
Yeah.
Right. So I don't think Nick Starro would work. I don't think that Becky Hill's quite right.
No.
Definitely not Valley Girl. I think Angry Man's probably.
Yeah.
Yeah, Angry Man. And
I'm working on more voices.
Yeah. Alec Baldwin is Angry Man. It used to be EB, as in Eric Bland, whereas now Alec Baldwin has taken over. But I think she's pretty angry.
Yes.
So that'll do.
Yeah.
That'll do. Yeah.
Consider I never thought I'd have any voices. 4 is pretty good.
Yeah, no, Angry Man is my favorite.
Yeah. And it works for so many people.
Yeah. Keep going.
All right. Any and all courts propose to be incurred to acquire investigator for and in the defense of her criminal care for trial. The defendant's requests are in good faith. Really? Keep going.
Oh, sorry.
No worries.
I got distracted.
And her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and representation of self. I have a dream.
Yay! What's the conclusion? What's the conclusion?
This temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial should be granted. Somebody got a thesaurus.
Well, that's pretty much what they say, though, right? Like when they do a conclusion, they say that this motion, for whatever it is, that like they say that this motion, and then they say the name of the motion, and then they say what the thing is for, and then they say it should be granted.
Fair.
So she's gone and looked up the template, and she's like filled in the blanks.
Yeah.
And she's written the whole thing out. So, cool. Nice job, Sarah. Oath. Oh, she's written out the oath. Under the authority of section, whatever it is, S925, Florida statute, blah, 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 blah. I have...
Pledge allegiance to the flag of the United States of America.
Yeah, all that kind of stuff. Sarah Boone, and then she's written Sarah Boone.
And then
she
signed
spells Sarah Boone, and then she signed it.
She should have Sarah Boone Esquire.
She should have written Esquire. That would have been awesome. That would have been excellent.
Yeah, Flash fan. That's what I was thinking is like, say what you will, but she's doing a pretty good job here.
That's the thing. I don't want to like it's kind of amusing, but it's actually I've got to give her props.
Yeah.
She has
As far
been
as this,
put in this situation, and I don't care what anyone says, she has been put in this situation. She did not ask to be pro se. She does not
no.
want to be pro se. She's just pissed some people off for a long time by being herself. She's just an annoying person,
Yeah.
right? It's not illegal to be annoying,
No.
right? It's
And being
not.
put in that I mean, and not being put in the position, but being in jail for something that you did not intend to do. A normal person would realize, okay, maybe you should kind of take it seriously. But Sarah's not normal. And
Not
either way,
intentional.
yeah,
Not
exactly.
intentional.
She didn't,
Well, hang
I don't
on.
know.
Do we need to get the violins out now?
Yeah.
All right. No, I gotta stop you there. Like we're not gonna start with the whole she shouldn't be in jail thing. Like
No, she should be.
we're not gonna sweep that hard. Uh,
No, she should
no,
be,
no.
or
Yeah,
at least be given bail, but if she can afford it. But
yeah.
I mean, her personality is not one where she would be able to work with a lawyer very well. So, and she was never really given a firm, this is the final deadline, which I think is what's important.
Okay, because now she was warned, and okay, so when I read what the judge's order, the judge did note that on this date and this date she was warned,
Mhm.
and she was also warned of the dangers of self-representation, but she wasn't told that this is the cutoff, like on attorney number 7 or whatever,
Yeah.
that's when this is going to happen, right? So I do feel that it was a shock to her that after Miss Cashman dumped her,
Yeah.
right? It wasn't the other way around. It wasn't Sarah saying, I can't work with Miss Cashman. It was Miss Cashman going, I can't work with Sarah. And I feel that there were 20 hours that those two discussed the case together. So it may have been a shock to Sarah that actually, like, she might have thought that this was going to continue. Like
Yeah.
they didn't like one another, but like
Yeah.
she doesn't get along with anybody. So maybe she thought that her and Miss Cashman were actually going to continue working together. Who knows? But Miss Cashman was like, nah, I've had enough of her. That's it. Right? So yeah, I just feel like there should have been something a lot more clear going on there. I have to wonder what she thinks her end game is. I don't think she has an end game. I just think there's got to be some lawyer that can work with her.
Oh, damn. She had a GoFundMe, but I guess it was taken down.
There was a GoFundMe. Because GoFundMe, it would be against their terms of service. If she had like Give, Send, Go would probably allow it, but not GoFundMe. I think the former Judge Wharton warned her. Yes, it was Judge Wharton, because a year ago, Judge Wharton was on it. There's too much effort being put into her. Yeah, I mean, people keep saying that as well, but it's the Constitution, isn't it? Finish this statement. She's doing a better job at lawyering than who? Saul Goodman, Daryl Brooks, Thomas Clare, Fluffer Boy Binger, Nick R. um, Bowles?
Oh,
Yeah, not a very tough choice, Max.
yeah, I'd say
Yeah.
Bowles.
Yeah, Bowles. It's weird that she doesn't understand they can't give her all their attention. I gotta say,
But
like,
it's Sarah's world. We're just actors in it.
Well, okay, no. Some of the arguments she made in some of the letters prior about these attorneys, I actually agreed with her. Like there was one of these attorneys, I can't remember which one, but one of them just didn't respond to her for weeks, right?
That's
And
fair.
yeah, and like she would send letters, and she would ask questions, and they just would say that they were going to have a Zoom meeting with her and then just cancel. And she was like, "Well, I what am I supposed to do when I have these?" And she was writing to the judge. What am I supposed to do when I need to have these meetings prior to these motion hearings, and then this person is just completely missing in action? And I feel like that's a fair thing to ask when she's just sitting in jail for a really long period of time. And this particular attorney, it was a male, I can't remember his name, um, and this particular attorney was just being like uncontactable for her. Um, it's got to be really frustrating. You're just sitting there in this pod, and like we've all seen these pods now. Like we saw it when we were watching the Chili stream. Um, Volunteerist tribute, Poppy. You like to believe you're a lawyer. That one got sick. Yeah. You have the right to an attorney if you can afford one. One will be a kind of yeah. Nowhere does it say you get to choose your appointed lawyer. No, I don't think she should get to choose. However, it's almost like they're getting to not choose her. That's how it's sort of turning out. They just keep dumping her, and I don't know if that's how it works either. All right, let's look at the other one. By the way, Dolly, the
Hmm.
response from the judge, is it in response to this one or to the other one?
Hold on. I think it's a combination response.
Okay, all right, we'll have a look at this one next then. Okay, this one's a massive one, so we're not going to murder you with all of it. Okay. So it's like a Court of Ninth Judicial Circuit, blah blah blah.
Be right back.
Oh, you're leaving now?
Yes. I'll be right back.
You're like, bye.
Bye. Bye,
I'm out.
girl.
Dolly out. All right.
Dolly out.
Dolly out.
Be right back.
Yeah, she is, Bobby, she is dumb for you, all right. Okay, motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. Yes, Sarah. Oh, hang on. I needed to share the right screen. I did a potentially criminal there. Share the correct screen. Sorry, Sean. All right, this lady is what you need. Standby counsel. All right, and I'm surprised that she has to put a motion in for this, because I think the judge should have assigned this right off the bat. So as soon as the judge said that you forfeited your right to defense or a public defender, there should have been standby counsel assigned immediately. So she's put in a motion requesting it. Great. Motion requesting immediate relief to the defendant by appointing effective standby counsel. So that basically means a lawyer who is not speaking on her behalf. She's still a pro se defendant, but there's a lawyer who is advising her off to the side, sitting next to her in court, writing up her documents, and just giving her advice. Kind of like, did you see, if anyone watched was it Daniel Jung, the one who did the terrible essay of the old lady? He yeah, it was a horrible break and enter and essay of the old lady, and he was a pro se defendant. he had standby counsel next to him throughout his whole trial, but he was pro se. He still questioned the witnesses. Do you remember the Young trial?
Which one?
Remember the pro se defendant who essayed the old lady?
Oh yeah, Bradley
Yeah.
Young.
Bradley Young. Yeah, that's right. He had standby counsel?
Yeah.
Yeah, yeah.
And
Okay.
Trevor Summers did as well.
Right. Yeah. Okay. So comes now. Oh, you can read this if you feel like it. Angry Man.
Coming now, Sarah Boone, pro se indigent defendant, respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included. Flash fan, that is a good point. He had counsel he was in contact with, but they were not allowed to sit.
Ty? Right.
He was not allowed to have counsel with him at the table, and they were not even in the courtroom. There was times like he pulled out his phone to text them, or like when he had the jury came back on the first time, and he had to like scramble contacting them to see what they thought he should do. So that was kind of messed up, and yeah, like
Yeah.
Okay, anyways.
Okay. Hit the like if you haven't, guys. Thank you.
Yes.
Keep
And
going.
subscribe. To assist and aid the defendant as a whole in the complex. Vital procedural preparation each with professional guidance during her forfeited right to counsel by the court as pro se attorney and in her proposed lawful representation of self in her criminal case. Defendant's justifiable reasons for requested relief and assistance are as follows.
Okay, let's go.
The defendant's sixth constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction by the defendant's lawful practice of her entitled first constitutional right to free speech and her God-given right to do so by writing her experience, derived truth, and providing red flag exposure in her correspondence to the court, requesting needed intervention to avoid present circumstances. She has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence. Hold on. Her defense of innocence.
No, turn it off, Yeah, you're crackling up.
Was that really?
Yeah, StreamYard's doing that thing.
If only there was a better alternative.
No, there's not.
I can't believe I was crackling up. She has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted, while having the ability to be leveled equally with the prosecution.
Oh, good luck with that, lady. No one's ever leveled equally with the prosecution. Yeah, you can have Jose Baez with his giant balls, and you still wouldn't be leveled equally with the prosecution. Although it'd be pretty close.
Yeah. All right. So the defendant is not an officer of this court or any court or legal system as a whole. She scrolls. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking requisite professional competency, experience, expertise in the field of law, presently and historically. Scroll.
Okay.
The defendant is defective.
She's defective.
No, I agree with her here.
Oh no.
Ineffective counsel to self is a result which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. 3, I have a dream that one day my children will not be judged by the color of their skin, but by the content of their character.
Okay, okay. Stop.
Rawr.
Where is she getting all this? Like, can you? Okay, I'm really impressed that she can write all this and not like make a mistake, need to like scrub things out, and it's all in pen. It's so good. Like, she's really good at writing.
Well, maybe she had a few rough drafts.
She never not needs to cross anything out.
And just like, God damn it, and have to start over again.
The whole Booner is defective. Yeah, defective Boone.
Defective Boone.
That's quite funny.
Defective
where did she get that from, though, right? The defendant is defective.
Well, because she saw lawyers can be defective and really? Ineffective assistance of counsel, so she assumed that would apply to herself saying being pro se.
I like ineffective, yes. I've never heard of defective. Recovery Addict said he don't think she wrote this one.
Maybe on civil law.
Who else would have? What
civil law?
Civil.
Somebody reached out to him, he said.
I'm not surprised.
He's a constitutional scholar.
Well, there's that. Plus, also, like, he's looking for a girlfriend, isn't he? Yeah.
I'll say my response in chat.
I think we'll leave that one. Anyway, it's possible that she has befriended somebody in jail who is more knowledgeable about these matters than herself. You would think that, like, because that happens, right? Like, I know that, like, Alex Murdoch, he makes money, commissary, by helping out mates in prison. Oh, yeah, by doing their legal documents. 100%.
I vaguely remember something like that, but yeah. Oh, yeah. I'm sure he
he's
would.
A lawyer. He's a lawyer, of course. Yeah. So, yeah, that mates in prison, they need help looking over their legal documents, need legal advice.
Yeah, as long as it's not a civil trial, they can get benefit from it.
Well, what's the difference if it's a civil trial or not?
Because he steals from them in a civil trial.
Well, I mean, you can only trust prisoners that much, can't you? Yeah, right. But I'm sure Bubble will come and get him if he steals, right? So anyway, that's the point. So I think maybe someone could have helped her, but still, it does sound a bit like her. There are things in here that are her, and because she doesn't take advice very well.
No.
So we know this
comes across as somebody who, I wouldn't say me because I've seen enough trials, read enough motions, but somebody who has never studied law, looked at law, all of a sudden forced into it and looking at everything, and then just trying to scramble out a really professional legal motion with everything they just learned.
Yeah.
And it's very good. Don't get me wrong. She's done a great job.
She really has.
But there's some things in it that just are like, you can tell she kind of confused things, like where she said she is ineffective and irresponsible. It's like, well, it doesn't really apply to pro se, sweetie.
Anyway, let's probably skip a little bit. We'll see how we can get through this. So yeah, Donna Buckley was a lawyer, technically was a lawyer, but it's kind of like if someone said that I can't be a graphic designer anymore, I still know how to be a graphic designer.
They can't
And
take away his knowledge and experience.
yeah, exactly. Or after the first time binge watching Law and Order, yeah.
That could be.
That was funny. Okay. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, blah blah blah. Okay. So now she's going to talk about the unfair burdens.
Aw.
Defendants not received from the court to date of this motion any of the promised discovery. Yeah, that's true. Just listen, see if I'm breaking up. With only 4 days to submit my demands and motions delegated by the court on before 22nd of the 7th, the defendant's not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court. Am I breaking up?
No.
Oh, really?
No.
Okay, good. The defendant does not have access to a computer. The defendant does not have access to the internet. The defendant has extremely limited, irregular access to basic tablets supplied by whatever that is, the jail. Defendant has access to payphones for collect calls only, limited to 15 minutes. Defendant does not have access to organizational supplies or production equipment, copier printer. Defendant does not have access to a meeting place for privacy in case review. Additional daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated. And once my case materials are finally received...
Do you want me to try again?
Yeah.
Continued application and reasoning in further lawful support of defendant's request for immediate relief with standby counsel to aid and assist in preparation of her criminal case. In all criminal prosecutions, the accused shall enjoy. Scroll.
Oh.
The right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law and to be informed of the nature and cause of the accusation. Semicolon. Good Lord, girl. Look at you. Using that Oxford comma. Naughty minx.
Oh, there you go. To be confronted.
Yeah, with the witness against him. And two semi-commas in 2 sentences? Oh, this girl's after my heart. I love a girl with a good grasp of the English language. It's my one weakness.
She could teach you.
She could. I'm just
You
saying.
Finished?
Yeah. I'm ready to get back. To have
Continue.
compulsory process for obtaining witnesses in his favor and to have the assistance of counsel for his defense. Amendment 4(6) United States Constitution. Right to counsel is assured by the 6th Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment, as well as state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance of counsel at each stage of the criminal proceedings and process. Ugh, making me want to revoke the 19th Amendment right now. Kidding. Oh, Hella got that. I wasn't sure if she would. Do you get it?
Yes.
Okay. Right to counsel applies whether the defendant can afford to hire a lawyer or not, in which the case will appoint without charge to defendant. Right to counsel, Burrier Law Dictionary 2012 edition. Ooh.
There you go. That's what she got. That
Breaking
that
out
law
the
dictionary.
barrier law. Right.
She went and got that one from the prison card. Yeah.
And they haven't updated it in 12 years.
Well, it probably still holds up.
It's
better than nothing.
Wait, Flash fan, is the hearing Monday?
Which, what?
Um,
What am I hearing on Monday?
8:05. 8:05, yeah. Status hearing.
8:05. What's 8:05?
Sorry, August 5th.
August 5th. Yeah, you have to talk in my language.
So
August
you're
5th,
6th.
my 6th. So that's Monday, right?
Yeah.
Your Monday, my Tuesday.
Yeah.
At what time? Do we know? Don't
Babu.
worry. That's fine. Don't worry.
It's not said automatically.
Yay! Okay, so Monday, we're streaming Boone.
8:45.
Yeah,
Wow,
well,
thank you.
we're not going. I won't be live with that. Oh, hang on, 8:45 a.m. Eastern. Is it Eastern?
Oh, yeah.
Ooh,
It's probably only
maybe
going to go an hour. I'll be at
maybe I'll
work.
stay up. Maybe
Yeah,
I'll
it's probably
stay
only
up.
going to go pretty short, but
8:45 a.m. is actually it's only like 10 p.m., 11 p.m. here.
it's a couple hours after you usually pass out.
Yeah, I know. Well, I could like have an early nap and get up.
Yeah. We can talk about it. So
Maybe I'll live stream it.
that would be cool. I mean, I can't be here,
Live.
but I can.
No, you can't. But you'll
I'll
be
be in
in
chat.
chat.
Yeah.
Yeah. How's that?
I'll be at work.
Too early for you, Harsh? Too early for you?
We'll
Yeah,
see.
well, it's super early. It's super late for me. Like I'm usually like
I know.
by then because I'm a sleepy one. But hey, we'll see. We'll see. I'm not Chinese. No, not Chinese. All right, let's keep going. All right. So look, I think all these things she's just listed out are absolutely fair, and she's made excellent points. Like, look at this. With only 4 days to submit my demands of motions delegated by the court on or before the 22nd of the 7th, defendant does not receive from the court to date of this motion any of her promised discovery. With the defendant does not have access to a computer. The defendant does not have access to the internet. Defendant has extremely limited irregular access to basic tablets supplied by the jail. Defendant has access to payphones for collect calls only, limited to 15 minutes each call. Does not have access to organizational supplies of production equipment. Does not have access to a meeting place for privacy and case review. Additional delay, obstructions, and undetermined hardships. Disadvantages, difficulties will likely come about due to being incarcerated, and once my case materials are finally received, continued application in reasoning and further lawful support of defendant, request for immediate relief with standby counsel to aid and assist in preparation for criminal case. Okay, she didn't need to say that. The accused shall enjoy the right to speedy and public trial, but impartial jury of the state. Okay. She does sort of flip back and forth, but she makes fair points that it's really difficult for her to prepare for her trial, which is 2 months away. It's 2 months away, and she's incarcerated and has very little access to anything in order to prepare, and she doesn't have her discovery yet. She does make a good argument for requiring the help of a standby counsel, but she really, really needs to put forth a motion for a continuance. I would have thought that would have been the first thing she'd ask for, motion for continuance, and this as well, like alongside it. I don't know where her motion for continuance is. Okay, let's move on. The right to waive counsel forced by the court. You want to read that bit?
The right to waive counsel forced by the court is the right knowingly to proceed in ignorance. It is sufficient for purposes of both the state and federal constitutions that the record taken in its entirety shows that the defense comprehends that a waiver of counsel means that they will proceed into the labyrinth of the law without the assistance of a trained guide.
Did she say labyrinth?
Yes.
She did.
Yeah, I didn't make that part up. It was a tamed guide, not a trained guide, but close enough.
Ah,
The court must first make inquiry into his competence and be reasonably satisfied of it before accepting the accused waiver of counsel never gave. Competence means more than a minimum of mental awareness. Ooh, sounds like when I go on a date. And capability. Just kidding. However, and involves an intelligent conception of the consequences of his act or her act. Bigots. People v. Holcomb,
okay,
47 Mishap
that's
4734.
very interesting. So she's gone and found this reference. So that must be in one of those law books that she has access to, because as half Irish, very very well noted, if she has no access to the internet, the ultimate question is, how does she know about YouTube lawyers? We've spoken about this before, and it just blows my mind, this whole idea of her knowing about how famous she is, right? And my question about whether or not in the jails, not so much the prisons, but in the jails, these inmates get to see us, right? So get to see the YouTube lawyers and the YouTube commentators watching their trials and watching their hearings and understanding what the commentary is that's going on. Because how does she know, right? How does she know about the fact that her interrogation went completely viral? How does she know that people are reading out all her letters and that she has all these fans, right? Unless like somebody is telling her on jail calls or something like that. I mean, that's possible, right? But it doesn't really sound like it. It sounds like she actually knows, like firsthand, right? What was the case that we were watching, Dali, when someone actually said that they saw it? Was it this one or something else?
I don't know.
Yeah. Um, yeah, this we need to find this out. We need to find this out from somebody.
Yeah.
Who do we know who's actually been in jail?
Wait, what was the
Oh,
question again?
sorry, you weren't paying attention.
Not really.
Okay, great. Never mind.
No, I was trying to find something Boone related to pull up. Sorry.
Okay. We're talking about whether or not it's these people who are in jail are aware and can see, because they don't have internet access
Oh,
apparently, whether they can see YouTube, whether they can see what's going on with their their inma- their inmates or cellmates hearings or themselves, like the
oh,
Sarah.
access to court TV, like
Yeah,
on TV, but that's about it.
court TV on TV.
Yeah.
Right, right. Yeah, that's not really. Maybe, yeah, maybe Solomon can ask that for us. That's a good question. Yeah, yeah, that's possible. If you read the order setting hearing filed on July 29, it will tell you all about the hearing on August 5. Thanks, Flash fan. That's cool. All right, let's keep going. The trial was a farce or a mockery of justice, or was shocking to the conscience of the reviewing court, or the purported representation was only perfunctory, in bad faith, a sham, a pretense, or without adequate opportunity for conference and preparation. People versus de Gravenfield, 19 Michigan, 702173 NW something. 1969. That's a long time ago. All right. She has gotten a few quotes out there from different books. Good for her. Due to ineffective assistance of counsel, the federal court in 1999 set this second sentencing aside Florida Constitution, Article 1, Declaration of Rights, Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness. Yes. Okay, so she's just basically going through her rights now. Section 5, right to assemble. Section 9, due process. Section 16, right of accused. Section 21, access to courts. The 14th Amendment. Yep. What's this one say? Do you want to read that one? It is vain.
It is vain to give the accused a day in court with no opportunity to prepare for it or to guarantee him/her/they counsel without giving the latter any opportunity to acquaint himself with the facts or law of the case. Every man is presumed innocent and, when accused, entitled to a reasonable opportunity to prepare his/her/they/them defense. Commonwealth v. O'Keefe.
Yep. Cool. All right. How many of these has she got?
Is this lawful law?
It looks like lawful law to me. Oh, she's got tons.
Boy.
Wow.
Her pillow talk must go all night.
I tell you what. Well, good for her, though. So these are all references. Look at that. Wow. Okay. So she's basically citing case law or like quotes from cases. Good for her. Federal Rules of Criminal Procedure, United States Code 2024, Section 44. Right to an appointment of counsel. Right to appoint a defendant who is unable to obtain counsel is entitled to have counsel appointed to represent the defendant at every stage of the proceeding, from initial appearance through to appeal, unless the defendant waives this right. Defendant, in brackets, defendant has been forced to forfeit her right to counsel from one-sided lies and unquestioned misinterpreted requests for understanding, intervention, for remedy, not removal from the defendant to the court in her criminal case. Well, you know what? She's getting it all down on paper. Whether or not this stuff is relevant, I don't know whether all of those things she cited up there are relevant, whether they're lawful law, as you say, or not. But she's putting all of her points out there, and somewhere within here there'll be, I guess what I'm trying to say is she has to say all the things, right? Like Josie said in chat yesterday, was it, or the day before when we streamed on this? She needs to get everything out there. Like when she's in the hearings, she's on her own now. So whilst her voice is annoying and we all think that it's quite funny when she talks, if she has a problem with something, she needs to say it. Like she needs to get it on the record, because all of these things are going to be potential issues for appeal later. And if they're not put on the record, then there's no lawyer who's going to do it for her. It's down to her now, right? Like, and her putting it into written form here, yeah, there might be lots of irrelevant stuff. It might all be written incorrectly, but at least she's putting stuff down. At least she's putting her complaints down. She's putting her requests down. So conclusion, this motion for immediate relief to defendant by appointing effective standby counsel to aid and support in preparation for her case for trial should be granted. Again, that is straight out of the template. Oath. Under the authority of Section 92525 Florida Statute and State versus Shearer. The defendant makes the following oath under the penalty of perjury. I declare under the penalties of perjury that I have read the foregoing document and that the facts and matters stated are true. Sarah Boone, signed Sarah Boone, written in her own handwriting. Wow. Check it out. Nicely done, Sarah. July 18. That was intense.
It was.
More intense than a row of tents. Jesus, she was bored. I feel, yeah, in a way, like, people like this, it's kind of like Ty Tucker. He said that, in a way, like, the reason why he wanted to go pro se was because he knew his case better than anyone, because he had so much time on his hands to prepare. Like, he had nothing else to do but to sit around all day and research and write all of this stuff up.
Yeah.
And that's what he did. Whether or not it was the right thing to do to try and go pro se, we can all argue back and forth till the cows come home. But he did know a lot about his case, and so did his wife. Unfortunately, what ended up happening was they found a way to put him in jail, and now he has to go with a public defender. As we said the other day, he's had to divorce his wife so that he can get a public defender. It's very sad. Anyway, Jesus, she was bored, yeah. She cites a lot of cases. Yeah, that's right, Flash fam. Hello, Melissa Simmock. Good to see you. Alrighty. What did I miss? You always miss everything, David. You always just miss everything. Basically, what she's done is she's put forward 2 motions to the court, and she's done not a bad job. She's trying to get standby counsel, which not a bad idea, I think. Don't you think, David? Good to see you. You can jump on if you want. Alrighty. Yucky, I'm not putting that on the screen, David.
David. Gross.
Ew.
Dirty man.
Ugh.
You're a dirty man. Shame.
Standby counsel was your idea. What did you tell her? Did you actually call her or tell her that?
Well, she asked for standby counsel in her motion.
Mm-hmm. Better than early justice.
What are you, true. My ex? God.
That's true. Nah. See, I was just going to say, that's Dali's problem. Anyway.
It's a compliment, ladies. God.
Anyway, what's this, Dali? What do you
got? Wait, no. On tab. What tab was it? There.
Don't do a Sean.
Hush.
Oh, hush.
Justice Administrative Commission's response to motion seeking due process costs. So, the defendant is seeking authorization for various due process costs as follows. Appointment of standby counsel to assist the defendant. Costs to take depositions in an unspecified amount for a defense investigator. Unspecified expert witnesses to assist the defense. Costs for unspecified witnesses to appear at trial. As an initial concern, any future request for due process costs, such as requests for transcripts, so on, need to be served on JAC prior to the court considering the matter. The defendant is responsible for providing JAC with any motions for due process costs so that JAC can respond accordingly to those requests. All right. JAC objects to any compensation rate in excess of established values.
Which is?
Standby counsel. As for the appointment of standby counsel, the court entered an order on June 28th, 2024, year of our Lord, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on the issue of appointed counsel.
Really?
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 Would I lie to you?
Well, she does not agree with that.
No, she does not.
No.
David, God damn it. Deposition-related costs. As for costs to take deposition, the defendant is authorized to incur costs to take depositions for those deposition authorized under the Florida Rules of Criminal Procedures. The notice of depositions substitutes for a court order for purpose of the court reporter seeking compensation of the appearance fees. As for service of process, service must be through sheriff unless the sheriff is unavailable to provide service of process. Was he on vacation? In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serve in-county law enforcement. 8. As for transcripts, JAC has no objection to regular paid rates. The motion in order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, date and type of hearing, and recording type and date of recording. The defendant should only order those transcripts necessary for defense of the case. I think she'll order the never mind. I forget his name. I'm blanking. Sorry. Anyways. Pursuant to the uniform statewide rates, the rates for investigators cannot exceed $50 per hour. Righteous bucks.
Is that good? Hang on. In US money, is that good?
It's like 4.5 times minimum wage.
Okay, but would that pay for like a lawyer?
Maybe
a standby counsel. David, would that pay for a standby counsel?
No, that's for an investigator. I'd say that's fair for an investigator.
You think?
Yeah, maybe it's maybe on the low end, but it's not bad, I guess. I mean,
no, Chinny says no.
No.
Okay. No, prostitutes cost more. I'm sure prostitutes do cost more. Like they cost tons, don't they? But so you think that they? Oh, you wouldn't know, right? Yeah. Sorry, shouldn't ask you.
No.
Okay.
No, they definitely don't cost $300 an hour.
No, they definitely don't. Look, dance teachers cost $300 an hour. So wait a sec. So they're saying
I need
that
to pick up dance.
So they're saying that can't exceed $50 an hour. Are you saying that we're talking about the investigator now, like the prison break guy? Are we talking about the investigator?
Yeah.
We are, right?
The rates for investigators cannot exceed 50.
Okay. So are we saying that the state is not going to cough up enough money for what it would actually cost to get someone to do it?
No more than 50. I mean, I think that should be enough.
No, that people in chat are saying it's not enough.
David says it's enough.
I was doing the dishes and I didn't hear the dollar amount. So the investigator... Oh, okay, David just said it is enough. So $50 an hour seems about right.
Yeah.
Okay. All right. Maybe like not like top of the range one.
No.
Yeah,
see?
Okay.
I'm smart. Right. I know things.
So, okay, we were talking about prostitutes and dance teachers and then that. Okay.
I know.
I said no when we said standby counsel. Yeah, okay. Because that's what I thought we were talking about, but we're not. Okay. I can't read the screen. I'm like, my eyes are... I need thicker glasses.
Based on the docket, or if the court grants the motion, the order needs to indicate the amount authorized for the defense investigator. Based on the docket, it appears prison break investigations, Billy Lane, may have already been appointed to this matter. Jack JAC does not object to the court authorizing $5,000 for a defense investigator and $500 for the investigator to obtain case-related documents and materials on behalf of the defendant. Expert costs. Ugh, experts are douches. But
Yeah.
we still have to hire them sometimes.
I wouldn't.
I know. I wouldn't, but sometimes they're needed. Based on Jack's JAC's records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. Now, I will say, I don't think $200 is enough for Sarah Boone. She needs much, much more than that an hour.
Yeah, that's true, actually. People should get compensatory rates. It's true. It's so true.
Oh, God.
Someone fit in a suitcase.
Excuse me?
Well, you're 6 foot something, aren't you?
Oh, okay. I thought you were saying I was overweight.
Nah.
Okay. Yeah, I am 6'2".
Like, I've never seen a profile photo of you or anything. I don't know if you're overweight or not.
A few pounds, but not really.
No. But I know you're 6 foot something.
2.
Yeah.
Jack does not object to the court continuing this authorization now that the defendant is representing herself, as do other requests for other experts. The defendant will need to file an appropriate motion delineating the following: identity or type of expert, the amount authorized cap for the expert services, and 3 rates authorized for the expert services. The defendant has the burden to show the particularized need for each expert witness. The defendant needs to show the services of the expert is necessary for the defense of the case. Oh, it's usually kind of hard.
As hire the Baldwin expert.
As enunciated by the Florida Supreme Court, a party seeking due process costs has the burden to establish the particularized need for the due process services and prejudice arising from the denial of the due process services. The determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and that denial of expert witnesses would result in a fundamentally unfair trial. Costs ordinary witnesses. The defendant will need to submit a more detailed motion delineating the witnesses she seeks to summon for trial and the anticipated costs associated with those witnesses. That's good for Sarah.
How would she know?
Well, once she gets discovery, she can probably plan more.
But there's no time.
Well, hopefully she'll request a delay.
Yeah.
If any providers desire direct payment in cash, the JAX procedure requires the vendor to execute the appropriate contract and follow JAX billing and audit procedures to obtain payment. Because of the unusual circumstances presented in this matter, Jack requests to participate in the hearing set on August 5th, 2024. Ooh. Jack requests to appear through communications equipment and can be reached toll-free at 866-355-7902. Oh, there's going to be a Zoom hearing.
When?
On August 5th.
Oh.
This looks like it might be a lengthy hearing, by the way, Hella.
Why?
Flash Fan said earlier it might be, and then Jack now has to get involved in this hearing, and there's several motions to get through.
Right, so I might not want to do it live.
No, well, it's not going to be like the 20-minute hearing from before.
Yeah. It's just okay. So, well, I mean, it could be what, a couple of hours.
I'd say 2-3 hours.
Oh God.
Guess.
Yeah. Well, I mean, like, I'd like to do it live. It's just,
Yeah.
okay, so that's 11 p.m. my time.
Yeah.
So like 12, 1, 2 a.m. Ah, everyone come and watch it with me.
Yeah, so all these motions are scheduled to be heard on Monday. Thank you, Flash Fan.
Thank you.
Oh, thank you,
Thank you.
Ghost. Does Chandler still have a channel?
Why would
Yeah, I think it's
okay.
DUI Guy.
Yeah, she does. It's called DUI Guy.
Well, I mean, she still has her channel. She just streams on
Doesn't use
DUI
it.
Guy.
Yeah.
But I'm really looking forward to you two crazy kids covering the trial.
No, I'm covering it with
David.
With David. I'm the new Chandler, and I promise I won't shag
Okay.
Larry. Promise. Anyway,
I don't think you're Jewish enough for him, so.
no,
You're too Catholic. Damn it.
too Catholic. Oh dear, I don't like white men,
That too.
and especially not ones that go. Anyway,
That looked like they'd be at the Whites for Kamala event.
no offense or anything. I just find that hilarious. Just the whole.
Oh God. Sorry, I just Sorry, I just got the idea to add him to the White Men for Kamala poster.
King of soy face.
Look, I'm not trying any drama. I'm not throwing any shade. It's just funny.
Oh
Like,
dear. Okay, no, it's kind of a little bit shady, but like it's just all funny. It's all funny. It's all in good fun.
I'm not trying to cause shit, so that's about all that.
Whatever. That's all we have to say about
and
that.
No, I
Anyway.
like Chandler. I like Chandler. I always got along great with her. When
she's
I
lovely.
started, she was very supportive, so.
She's lovely.
Yes.
She's lovely. Okay, yeah, we don't do drama here, bro.
No.
Love you, bro.
Love you, brother.
Love you, brother. Not here. All right. Not the D word. No D word here.
I apologize. I should not have said anything.
Just FYI on that, if we did do drama here, there would be not 18 people in chat. There'd be 1,800 people in chat. Because that's how you get 1,800 people in chat.
Trust me. The amount of shit I could say.
Yeah. Because no shit, like that's why big crowds come into chats, when you start throwing a lot of shade around. Yeah.
So fuck this god of law. Who the hell is that idiot?
Yeah,
he's so arrogant. God.
Yeah, tell you what. Love you, David. You know what? I heard he's gay.
I did too.
Yeah, and I have some DMs of his that. Do you want to see them? I'll bring them up on screen.
Yeah, I hear he sent his dick pic to you. Melissa? Yeah.
Hang on, the numbers are starting to go up.
Yeah, Chandler started around like the time we did. And then she got in with Legal Vices and kind of became popular. But she never really did anything with her channel. Which was a shame, because I thought she had a lot she could have done.
No, she did. She was doing okay with the channel for a bit.
She just didn't put out content on a regular basis.
Yeah. No, the channel was all about about men.
Yeah.
Misandry or something. Yeah. Anyway, can we move on?
Yeah,
Yeah.
please.
You were reading.
I finished.
Oh, it's done.
Yeah.
Okay. So did they actually get to the point about how much the standby counsel was going to be?
Um. Oh no. Yeah. They denied standby counsel.
David.
God damn it, David.
Look, nothing wrong with baby carrots. They're very nutritious. Oh yeah. Chandler is actually she has so much clout on Twitter because once Elon responded to her. And
Well,
if
I'm a little
Elon
jealous of
responds to
that.
you, if Elon responds to you, phew,
Yeah, I'm
that's what
jealous of that.
happens. We all are. Like, imagine getting Elon to respond to you.
I
I
know.
remember the day it happened. I remember the day it happened. It
I
was just like,
tattoo it on me.
oh yeah, it was huge that day. That was full on. Yeah.
One time, yeah. Yeah, I was like
Yeah,
really
oh
jealous. I was like,
yeah.
holy shit, wow.
He did. It because she posted something about going to her therapist and the
Oh,
therapist saying that it was all about the way men treated her or something.
it was all her
And
female therapist that she went to.
yeah,
And
and
then she
then
went to a male therapist finally. And like he gave really different advice and like really helped her.
yeah, that's right. And that's right. Elon retweeted one of her tweets. It had
One
nothing
of
to do
my
with
tweets.
no, it had nothing to do with your YouTube channel, David. Nothing at all. How dare it be nothing about your YouTube channel? And all of a sudden, like, yeah, her Twitter went berserk, and ever since, every single one of her tweets and everything has just been like nuts. So she's like Twitter influencer now. Ever since then, so yeah, I remember the day it happened. It was just like, oh, Chandler, you're famous. Yeah.
Yeah. Anyways, no shade to any of these people.
No, no, no.
I'm not, yeah.
She's lovely. I
Yeah.
really like Chandler.
Yeah.
Really like Chandler. Okay, so I hope that Sarah Boone has this motion especially. This motion needs to be approved. This needs to the judge needs to have the standby counsel. Well, not the one that's on screen right now. The one that I'm just going to share this one instead. So this one, which is asking for relief. Back here. David, if you haven't seen this one, so what we were looking at before, motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation for her criminal case for trial. This here, judge, it's been received by the judge. Judge, you need to uphold this one. This is so important. She needs help. And I really hope Sarah Boone, the next one that comes from her in the next day or so, is going to be asking for a continuance. So we should have a motion for continuance any day now. That would make me happy. I would hope that the trial wouldn't happen until probably March next year, something like that. And she gets a good standby counsel. I feel sorry for whoever it is. I'm sure that this person is going to need a great lot of patience to put up with her. But as we all know, she's a lovely lady and she needs help. As she's just said in this 29-page document where she's very clearly, she was denied. What, Chinny? When was she denied? She hasn't been denied yet. She hasn't been denied standby counsel. Have you seen something since then that I don't know about? Let me check. Alice in Dreamland. Ali, come back. You just read it? No, no, no. No, no, no. That wasn't them denying it in that last document. They were just talking about the costs. Something new happening today, not sure what it is yet. 2 seconds, guys. He has to leave now, doesn't he? How many standbys will she go through? They denied it. What, in that document? Just a sec. Just a sec. Just a sec. Yes. Where exactly in that document did they say that she would not get standby counsel, Chetty? Dali, where did we miss in that document that it said that she would not get standby
I
counsel?
told you.
What?
Okay, so where do we go? Standby counsel. As for the appointment of standby counsel, the court entered an order on June 28th, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on the issue of appointed counsel.
So, hang on. So he's saying, so the judge is saying now that because the judge has said that he has already ruled on her having any counsel at all that
Yeah.
includes standby counsel.
Yeah,
So that's a catch-all that includes standby counsel too.
sounds like it, yeah.
That's bullshit.
I thought so.
That's bullshit. No.
Then again, I mean, if she wants regular counsel, so I couldn't standby counsel be that, so.
Hang on. Flashback. This is their response. It has not been ruled on yet.
Oh. Okay,
yeah,
so
go to the end. Well, where's this from?
This is from the Justice Administrative Commission.
Okay.
So, okay, maybe the
so
judge.
It's the state.
Well, it's a division of the state, so I guess then. Okay, wherefore the Jack request, should the court grant the defendant's motion, also include in its order the specific due process service authorized, as well as hourly or per unit rates maximum fees authorized. So this is an outside agency of the court who is asking the court to kind of make a decision on what is allowed for Sarah. And they get to argue Monday, yeah, as Flashfan says. Thank you.
They get to argue it on Monday. So, Chinny, yes, he has ruled on there being counsel previously, but I think Flashfan might be right. I think that there's not been a final decision made, and they can argue it on Monday.
On standby counsel, yeah.
Yeah. Because you're right, like the judge's signature is not at the bottom of this, right?
No. This is a administrative general counsel of the Justice Administrative Commission.
Yeah.
So it's it's the agency that decides or is part of giving funds to defendants to defend themselves in court.
Yeah. And so as an agency for the state, they've worded it in such a way that it looks like if you go back to that paragraph where it said standby counsel.
Yeah. As for the appointment of standby counsel, the court entered an order on June 28th finding that the defendant waived her right to court-appointed counsel through her conduct. Thus, the
Yeah.
court has already ruled on the issue of appointed counsel.
Okay, so it's in their interest to word it like that
Yeah.
because it looks like the judge has ruled that all counsel has already been
Yeah. So they
wiped
won't
off
have
the
to spend the
table.
money.
Yes, right. So they put the heading standby counsel, and then they put the whole paragraph under there that goes, "Hey, he's already ruled on this," right? And yeah, I know, Chinny, he has ruled that she has forfeited her right to counsel, but she's now put in another motion to say, "Can I please have standby counsel?" So why is that not able to be considered at this point? And I'll let you answer. Like, if there's a reason why you think that that's not possible for her to now argue for that, then cool. I'm interested to hear why she couldn't argue for that now, considering he's ruled for her to have waived her right to an attorney or public defender. But isn't standby counsel like a different thing? Because she's pro se. Like, pro se defendants can have standby counsel. What makes you think he's going to change his mind? Well, it's not changing his mind. That's a different thing, isn't it? To have a standby counsel is a different thing to having a public defender actually representing you. So it's not really changing his mind. In fact, I would have thought that if at that point where he said, okay, now you're a pro se defendant and you forfeited your right to having a public defender, he would have actually just assigned a standby counsel for her. But he said, okay, now that's interesting. So when did he say no to standby before? Because I've missed that part, if that's the case, Chinny. I've missed that part, if that's the case. Yeah. And that's why I said, like, what, it's a different thing. And it's not really changing his mind. I've missed that, if that's the case. Lawyer No made a comment that she'd probably treat her standby counsel like they were her lawyer. Look, that's fine, but I mean that's an assumption, isn't it? We can't take someone's rights away because we're assuming that they might behave in such a way that they did before. I think she can argue it. I don't think she will get it. Are they going to go through 8 standbys till she finds what she likes? I mean, yeah, don't know. It was around the time when he told her she had to go pro se, and then so he ruled at that time, did he? Okay, I'm going to go back through the document that he wrote at that time and see if I can find something about standby counsel there. There's one section in there where he talks about her forfeiting her right to counsel, and I'll see if I can find actual clear wording about standby counsel as well. That's fine. Yeah, Ginny, cool. I'll have a look at that because I was reading it yesterday and this morning. It's still morning here. I was reading through that section of the document to try and work out just his reasoning behind the decision for having her waive her right to counsel, and it didn't occur to me that he might have also ruled on the standby counsel part. I don't remember reading anything in there about that, but I'll go back through it with a fine-tooth comb and make sure that that wasn't mentioned specifically. Yeah, no, that's okay, Jenny. I'll go through it and check. Yeah. Some states don't have standby counsel for pro se defendants. I don't know if Florida is one of these. No, well, we know that Ty had one, and that was Florida. Right, Darlie? Oh, you're muted.
Sorry, I was sneezing. I had allergies. Ty
No.
did not have one. No.
He had one for a while.
Well, he had an attorney he could contact that was working for him. The attorney was not allowed to be there with him in court.
Ah,
or
okay.
even behind him in court, frankly.
But okay, but wasn't that just that judge's decision?
It was the judge's decision, yeah.
Yeah. So it wasn't like a this is always how it is.
And he may have been paying for that lawyer too.
That's right, he was paying for that lawyer. So that wasn't a public defense
And the lawyer
situation.
was then not allowed to even be with him during trial,
Correct.
which is bullshit. But
Correct. Correct. Yeah. Don't know if Florida is one of these at all, AG. So
no, I've seen standby counsel in Florida trials.
okay, sorry, you were muted, so I don't know. You might have tried to answer that earlier.
Like 20 minutes ago when I wasn't, but yeah.
Okay, right. It could be in the notice she got to go pro se. Yeah, that's the notice I'm talking about, Tinny. So I've been reading that one over the last day, and I wasn't specifically looking for that wording. So I will go back and look through it and see if I can find any wording. Yeah, that's the one. It's a 16-page order. Yeah. And he keeps referring to, yeah, in my 16-page order, I gave you warning that you will be you'll not be assigned another attorney. These and also of the dangers of you going pro se, la la la. Refer back to that, Ms. Boone. And so I've gotten out that order and been through it, but I didn't look specifically for wording regarding the standby counsel. So I will go back and have a look through it. For what I heard, it's up to the court if a pro se gets standby or not. Yeah, okay. And the judge must really love his 16-page order. Yeah, he talks about it a fair bit. And that's fair enough because she keeps bringing up the fact that she didn't waive her right to public defense. Okay, this is getting really interesting, and we will definitely stream the hearing on Monday, whether it be live or not. We'll see. Hey, Bob, you just turned up at the last second. At the last second, so you'll have to rewind. Good to see you, though. Alrighty, but yeah, for sure, I'll have a look at that wording and see if I can see where he has, if he has already ruled on this. But I tend to think that since she's put that motion forward, that he should at least entertain it, like bring it up at the hearing on Monday and at least say, I've already ruled on it, or okay, this is why you can or can't have it. Yeah, thank you everybody for being here, and justice for Sarah Boone. She may have put a man into a suitcase and gone, for all you did to me. That's my name, don't wear it out. She might have done all that stuff, but you know,
Yes.
the Constitution is for everybody.
And Hella, do you want to promote your next stream?
Oh, why not? Tomorrow, actually, thank you, Half Irish. Tomorrow is going to be a new topic. It is actually really interesting. Oh, Max is back. What did I miss? Yeah. In Nevada, stop it. In Nevada, are you okay? There is this judge called Mary Perry, and she says stuff like, "Are you a psycho?" And there are much better parents getting around than you. I'm surprised your kids are even staying with you. Anyway, she's, yeah, a family court judge. Lovely, right? Bit of an old granny. Get this. The Supreme Court has censured her, which means that she's been officially reprimanded and also been suspended without pay for 30 days. Wait till you see the censure document, because there's all sorts of really crazy stuff that she's been saying. Ugh. Mucus much? Okay, thank you. Yeah, and there's some clips of her being crazy, and apparently she's blaming it on the meds. She's on some sort of meds that make her have outrageous outbursts in trial situations and stuff like that. Is that okay? I think not. Crazy Judge tomorrow, 7 p.m. Eastern. Make sure you're there for that. Yeah, Naughty Judge. Naughty Judge. There's N-words there too. Lots of talk. Oh, standby cancel. Oh, yeah. Okay, Max is back. What did I miss? Discord post with N-word. Yeah. Kind of. No, I don't think it's like Tourette's, but she just like family court is pretty hard to deal with at the best of times, I think. And this lady, she just loses it. Like she gets to the end of listening to all the arguments and then she's just like that. And yeah, people have they've gone and reported her. And there's been too many people report her and that's it. So yeah, wait till you see it. You will not believe this when you see it. You'll just be like, what the? I occasionally get dander in my eye and it waters a lot. Is that what happened?
Yeah. I'm slightly allergic to my cats. Like
Right.
it's like once a week I get like dander in there and I water and have to blow my nose.
Oh, okay. Bamboo Kitty is innocent of all charges.
Yes.
Yes, indeed. All right. Thank you everyone for hanging out. Today was fun. And tomorrow's going to be really interesting. Lots of Tourettezepam, as you say. Tourettezepam.
And she's like Judge Borowski on steroids in female form.
Yeah, Granny Borowski.
Granny Borowski. Yeah, this is Judge Borowski's grandmother.
Yeah. She even made it onto a Law and Crime Sidebar.
Yes.
Right? Like, that's how I actually found out about her. Like, they were talking about this nuts granny judge in Nevada who's been sanctioned. So,
and then I found like this other YouTube channel that has a bunch of her stuff and she's just spurging out all the time.
Spurging.
Suffer, Granny Borowski, suffer.
Yeah, suffer. All right, that's it. Thank you everyone for hanging out. It's been fun. See you tomorrow. Are you streaming tomorrow?
Yeah.
Okay. Oh,
5:30.
Hang out there.
Yes, please. More of Alec Baldwin.
Yes. All right.
Well,
cool. Let's go. Oh.
Toodles, Max. Irish, Ghost, Penny. Thanks everyone for being here, Flash fan.